everybody. This one is about do-it-yourself Kangaroo Courts number 8, copyrighting the name. People have contacted me about procedures and all of the rest of it for copyrighting the name. And, you know, this is my thoughts on all that. So this is number 8, so we'll go through the first 7. The term kangaroo court is a term descriptive of a sham legal proceeding in which a person's rights are totally disregarded, in which the result is a foregone conclusion because of the bias of the court or of the tribunal. Part 1, we talked about all courts, 2 general kinds, 3 general types of jurisdiction, what a kangaroo court is, why they're holding a kangaroo court, why they want you to have a liar, and how to tell it's a kangaroo court and what to do in a kangaroo court, and how they are Satanists. Part 2 went in further on how to tell it's a kangaroo court, what they do in a kangaroo court, and it further went what was been done by others to defeat the kangaroo court without going in there, and some things to do if they drag you in there. Part 3 is why they want you to plea bargain, and what happens if you do enter into a plea bargain. Part 4 is it's Roman cult commercial warfare. It's a contract. So where's the contract? Where's the benefit that I'm supposed to have taken advantage of that subjects me to this? Admit nothing, make them prove everything, object to everything, and reject their contract at allocution. Part 5 is object to testifying by the liars. It's an admiralty proceeding, and the so-called judge is a clerk masquerading as a judge. The clerk is sitting there playing stupid, and if you do not object, then the bail priest will accept it as true. Part 6 is how all courts are United Nations courts operating under UNIDROIT, and the UNIDROIT is a law merchant, which is the Uniform Commercial Code. There's no common law because of martial law, and martial law is in place because of bankruptcies, military occupations, and no money. Judges are bought and paid for. Clerks collect a royalty. They sell you into slavery to populate the prisons. That's what it's all about. Part 7 is the biggest presumption that they're making is that you're one of their U.S. citizens' slave trusts. And so this video, part 7, was about defeating that presumption. It's the corporate denial. And then part 8 is copyrighting the name of the Satanic trust slave. You have to treat this like it's warfare. It's exactly what it is. And you have to fight them every possible way you can. And copyrighting the name is one way that some people do fight these Satanists. And but it's not necessary to comply with their statutes for a common law copyright. That's what we're going to talk about today. Matter of fact, you absolutely, in my opinion, you cannot have anything to do with their statutes, or you turn yourself into a slave. Matter of fact, I deliberately do stuff that's common law because of that. Common law really is the only real remedy. So we're going to go into UNIDROIT here first of all. UNIDROIT stands for Unification of Private Law. The website says 63 countries have adopted it. It's designed to be automatically implemented. In other words, when UNIDROIT does something, then it's supposed to filter down to all the countries. It's supposed to be automatically implemented in all the countries. So they don't pass a law. They just automatically just do it. Canada and the United States have been signatories to the UNIDROIT Treaty for over 30 years. The UNIDROIT website says it was designed to be automatically implemented. UNIDROIT makes a change. All the signatories of the treaty are required to make the same changes. They don't pass statutes. This is the UNIDROIT website. Let's get a little closer. Talks about commercial contracts, cultural property, franchising. Another page here. Notice at the top the header, UNIDROIT, International Institute for the Unification of Private Law. Leasing, security interest, transport, banking law, capital markets, civil procedure, contracts, cultural property, franchising, hotel keepers, insurance, intellectual property, leasing, legal status of women, maintenance obligations, movement of persons, negotiable instruments. UNIDROIT covers mandatory insurance for motor vehicles, anything related to children, and to marriage, divorce, and children. This is, again, another part of the UNIDROIT website. Talks about the 1955 Benelux Treaty on compulsory insurance against civil liability in respect of motor vehicles, and 1958 Convention concerning the recognition and enforcement of decisions relating to maintenance obligations towards children. 1959 European Convention on compulsory insurance against civil liability in respect of motor vehicles. This is talks about the website. These are the states that have acceded to the UNIDROIT statute, and Australia, Canada. If you want to look at any one particular, this isn't the whole thing. This is just a couple pages. There's 63 of them. But it shows United Kingdom, United States. This is the International Covenant on Civil and Political Rights, Article 2, Clause 1. Each state party to the present covenant undertakes to respect and to ensure all individuals within its territory and subject to its jurisdiction and the rights recognized within the present covenant without distinction of any kind, such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status. This is all Roman law. Okay, that's the point. It's United Nations is Roman law, which goes to the Roman cult. This is the Article 2, Clause 2 of the International Covenant on Civil and Political Rights. Where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So, you know, they're basically saying the states have to pass laws that give effect to all this stuff. This is Article 2, Clause 3. Each state party to the present covenant undertakes to ensure that any person whose rights or freedoms are herein recognized or violated shall have an effective remedy, notwithstanding that the violation has been committed by persons acting in an official capacity. B, to ensure that any person claiming such a remedy shall have his right thereto determined by competent judicial, administrative, or legislative authorities, or by any other competent authority provided for by legal system of the state to develop the possibilities of judicial remedy, to ensure that the competent authority shall enforce such remedies when granted. So, and the state parties to the present covenant undertake to ensure that the right of men and women, okay, enjoyment of all civil and political rights is set forth in the present covenant. That's the Article 3. This is Article 16. Everyone shall have the right to recognition everywhere as a person. Okay, so they assault you with their person. And this is actually an article I found on a blog. Talks about the death of London's Roman Empire by Lyndon H. LaRouche. And so it goes back to what I'm saying here in the header. United Nations equals Roman law equals Roman cult. Okay, this is all the Roman cult. This is Roman law. The London's owned and operated by the Roman cult. Anyway, so a little diversion here, an advertisement. Don't forget to subscribe to this channel. Don't forget to click the bell next to the subscribe button so that you're notified when there's a new upload. And there is my front page of my channel, and the arrow is pointing to the bell. You got to click that bell and you'll be notified when there's a new upload. And back to the topic at hand. Military occupation equals Satanism. Okay, this is all Satanism. Territory is considered occupied when it's actually placed under the authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. And this is the law and customs of war on land, Hague Convention 4, Article 42. So when they invade, it's occupied. Okay, and so then this is Article 2 of the Geneva Convention relative to the protection of civilians in a time of war of 1949. And in addition to the provisions which shall be implemented in peacetime, the present convention shall apply to all cases of declared war or any other armed conflict which may arise between two or more of the high contracting parties, even if the state of war is not recognized by one of them. Okay, so it doesn't necessarily have to be recognized by both parties. There's no declaration of war. Any armed conflict. Okay. And the convention shall also apply to all cases of partial or total occupation of the territory of a high contracting party, even if the set occupation meets no armed resistance. Okay, so then if they just walk in and take over. And then although one of the parties in conflict may not be a party to the present convention, the parties who are parties thereto shall remain bound by it in their mutual relations. Okay, so in other words, so this is talking about basically the Indian Territory. Okay, everything, if you look at the Treaty of 1763, the map, everything west of Quebec and everything west of the 13 colonies was Indian Territory, and that's all under military occupation today. Anyways, and so I'm saying that the Indians didn't recognize the state of war in some cases, and the Indians sometimes there was no armed resistance, and the Indians are certainly not part of the convention. That's the reason that the courts have ruled that the government has to settle Indian land claims because they stole a land. This is Article 1 of the Liber Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under martial law of the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of the hostile army proclaims its martial law. Okay, so again, the hostile army, just because of the fact that the army's there, okay, that's the martial law. Martial law does not cease during the hostile occupation except by special proclamation ordered by the commander-in-chief or by special mention in the Treaty of Peace concluding the war, when the occupation of a place or territory continues beyond the conclusion of peace as one of the conditions of the same. So the martial law can only end by when there's a special mention in the Treaty of Peace, and I can tell you that I've read a bunch of treaties and none of them talk about martial law ending, and or by a special proclamation ordered by the commander-in-chief. So that would be President of the United States in the USA or the Prime Minister in Canada. And there's been no declaration. And in Canada, it's the RCMP is the occupying force. This is a book taken from a book called The Non-Ratification of the 14th Amendment by Judge H. Ellett of the Utah Supreme Court, that's associated with this D.I.Y versus Turner case. Now, and he has the entire Liber Code in there, and every section, Article 1, Article 2, he goes and this is actually a comment that he makes on Article 3. And it has relevance in Canada or wherever because it talks about what goes on in a military occupation. Note, under the law martial, only the criminal jurisdiction of a military court is a recognized law. But as Article 3 says, the civil courts can continue wholly or in part as long as the civil jurisdiction does not violate the military orders laid down by the commander-in-chief or one of his commanders. By this means, a military venue, jurisdiction, and authority are imposed upon the occupied populace under disguise of the ordinary civil courts and officers of the occupied district or region, because the so-called civil authorities in an occupied district or region only act at the pleasure of a military authority. It should also be noted here that the several state legislatures, county boards of commissioners, and city councils are constantly legislating to please the edicts of the federal government, the occupying force, and that their legislation in this sense is not an exercise of state sovereignty, but instead a compliance with the edicts of the military force which occupies the several states and consequently are edicts of martial law rule. And so again, I mean, everything they do is under martial law. This is concessions to the England to the Pope, 1213. Okay, so England was put under martial law with this. We will establish a perpetual obligation, and concession will establish that from the proper and especial revenues of our aforesaid kingdoms, for all the service and customs which we ought to render for them, saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks, and at Easter 500 marks. And then they say 700 is for the Kingdom of England and 300 is for the Kingdom of Ireland. And so, again, this is what puts England under martial law. And then it only took 2 years for the people to figure out what's going on and rise up in rebellion, and the Magna Carta was the result. That's the bankruptcy that happened. This is bankruptcy in the United States. Since March 9th, 1933, this is one of several bankruptcies, actually. The United States been in a state of declared national emergency. Under the powers delegated by these statutes, the President may seize property, organize and control the means of production, seize commodities, assign military forces abroad, institute martial law, seize and control all transportation and communication, regulate the operation of private enterprise, restrict travel, and in a plethora of particular ways control the lives of all American citizens. A majority of the people of the United States have lived all of their lives under emergency rule for 40 years. Freedoms and governmental procedures guaranteed by the Constitution have in varying degrees been abridged by laws brought into force by states of national emergency. And that's taken from U.S. Senate Report number 93-549, dated November 19, 1973. And then this is a congressional record. And notice the dates. It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act, March 9, 1933. Notice that, March 9, 1933 is when the government went bankrupt, and March 9, 1933, it went into a declared state of national emergency, martial law. And so anyways, 48 Stat 1, Public Law 89-719, declared by President Roosevelt being bankrupt and insolvent. HJR 192, 73rd Congress in session June 5th, 1933. Joint resolution to suspend the gold standard and abrogate the gold clause dissolved the sovereign authority of the United States and the official capacities of all United States governmental offices, officers, and departments, and is further evidence that the United States federal government exists today in name only. And that's U.S. Congressional Record, March 17, 1993. Now, notice it says that the joint resolution to suspend the gold standard and abrogate the gold clause dissolved the sovereign authority of the United States. Okay? If they can't pay their debt, they're not sovereign. That's the key here. And that's what put it all under martial law. At common law, only gold and silver are legal tender. Okay, so if there's no money, you're under martial law. If it's bankrupt, you're under martial law. If you're under a military occupation, you're under martial law. And further evidence of this is there's no common law crimes. And there's no common law offenses against the United States. Only those acts which Congress has forbidden with penalties for disobedience are of its command are crimes. And Texas is the same way. Well, Texas is under military occupation, isn't it? Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. Everything is in admiralty. A root of error doth not lie upon a sentence in admiralty, but an appeal. And that's taken from Tomlin's Law Dictionary, 1835 edition, under the definition of admiralty. But it's citing Book 4 on the Institutes of the Laws of England from Coke in the 1500s. Appeals are in admiralty. It's called a court of appeals. It's always courts of appeals. In Canada, there is no Supreme Court of Alberta. It's a court of appeals. And the same thing in any other province, Ontario Court of Appeals, okay? And this is the same thing that precipitated the War of Independence. And Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish an order in use and exercise of law martial. And so that's taken from the Causes and Necessities for Taking Up Arms, 1775. And this non-ratification of the 14th Amendment by Judge A.H. Ellett explains it a little bit differently, but it's the same thing in this Diet versus Turner case. In the meantime, civil law was the form of law imposed in the Roman Empire, which was largely, if not wholly, governed by martial law rule. Equity has always been understood to follow the law. To have superior equity is to turn things on their head. That's exactly what happens when martial law is opposed. If equity is a law, then it follows its own course rather than following the common law, thereby destroying the common law and leaving what's called equity in its place. And so what he's saying, okay, this is basically the same thing what happened with what they're saying in the Causes and Necessities to take up arms, because equity is normally supposed to follow common law. But when common law is destroyed, then equity can do literally anything it wants, and these UN bail priests in the courts will tell you that I can do anything I want in this court, and they'll be 100% correct. And this is the Declaration of Independence for abolishing a free system of English laws in a neighboring province, establishing therein an arbitrary government, and enlarging its boundaries so as to render it once an example and fit instrument for introducing the same absolute rule into these colonies. Well, that's military dictatorship, people. He's abdicated government here by declaring us out of his protection and waging war against us, okay? That's military dictatorship, people. For protecting them by a mock trial, the Founding Fathers had a far better understanding of what's going on than we do today, no doubt. And if you think about it, the Declaration of Independence is really just a list of grievances. And those are just some of the grievances. You read through the whole thing and you can tie martial law to all of it. And this is, again, the non-ratification of the 14th Amendment by Judge A.H. Ellett, Utah Supreme Court, associated with the case Diet versus Turner. Congress, claiming its martial law power to declare war, suppress insurrections, and repel invasions, imposed martial law in the United States and never discontinued it. The result was an extension of military and municipal jurisdiction of Congress. But where's the evidence of this? Look at the 13th Amendment, the 14th Amendment, or I should say the Civil Rights Act, the legal tender laws, the 14th Amendment, etc., etc., etc. And it goes on, the 14th Amendment is an extension of the national military powers presently used in a municipal character and enforced by municipal laws stretched far beyond their original limitations and enforced by Article 1 tribunals, okay? There's no Article 3 courts. The same thing is going on in Canada. This is a social insurance number instruction sheet, and it says in paragraph D, if you're replacing your SIN card, you must pay the $10 fee and make your check bank draft payable and Canadian funds to the Receiver General for Canada. Well, think about it. That's a receiver in bankruptcy. Watch the bankrupt corporate so-called governments video. That's why they make statutes for common law crimes like murder, assault, theft, etc. Because under martial law, there are no crimes unless they make it a crime. That's why they make statutes to protect common law rights, which converts rights into legislative privileges. And now a little diversion, an advertisement announcing a subscription-based YouTube channel called Sovereignty International. The recommended cost of the subscription is currently at $1.99 because it avoids the advertising only. Originally, when I started setting up this YouTube channel, I was going to have exclusive material on it. And then I started thinking, well, the only power that these New World Order Satanists have over us is through fraud and deception. And my agenda is to expose it for all our benefit. And so I can't think of anything that I want to have exclusively on there that I wouldn't want to have available for free. And so there may be exclusive material at some point, but I can't think of anything right now. And at some point I may put some exclusive material on there. So the only advantage is that you're going to avoid the advertising, but it's only $1.99 too, and it's a great way to make a donation if you want to make a donation. And I'm currently publishing 6 videos a week. And people had trouble finding the channel too. That's another thing. So I put a link at the bottom of the video. There's also a link at the top of this screen right here. And that's the front page of the channel. And also another thing I'd like to mention is somebody actually sent me $1.99. Now, they never did communicate with me what that was for. I sent them an email, but so the bottom line is that they haven't responded. So, but I cannot add people to the subscription to this. All I can do is it has to go through YouTube. You have to click that start free trial and get that $1.90, and you know, there'll probably be some payment arrangements or something. I don't know. YouTube handles all of that. I might be able to remove someone if I needed to, but beyond that, I have no control over any of that. And so you're going to have to, if you're interested, click the start free trial and go through whatever YouTube wants you to go through. Anyways, back to the topic at hand. Under martial law, they want to assault you with one of their liars, okay? And who is a liar? Well, he is, however, in a sense, an officer of the state with an obligation to the court. That's Book 7, Corpus Juris Secundum, Section 4 on attorneys. His first duty is to the courts and to the public, not to the client. And whenever his duties to his client conflict with those as an officer of the court in the administration of justice, the former must yield to the latter. And clients are also called wards of the court, okay? And a ward of the court's an infant of persons of unsound mind, and that's Black's Law Dictionary, 4th edition. A ward of the court is an imbecile, okay? If you hire a lawyer, you're saying you're an imbecile. A ward of the court is not competent. Everything is about competence and incompetence. That's why they're representing you, because you're not competent to make decisions for yourself. Therefore, the attorney's going to make the decisions for you. There's no such thing as an incompetent sovereign. Do you know who you are? And so they can assault you with one of their so-called contracts, okay? This has nothing to do with justice and all about contracts, okay? It's all commerce. And that's why you got to think about what you're going to do when you're going to copyright the name. I have forms that are available. My blog, I've got a document that I put on my blog, and there's on my Yahoo group. There's forms that are available that you can modify to suit your particular situation. So if you want to copyright the name, but I'm going to go into that a little bit more. I'm just going to finish up the stuff about these contracts with these bar members, okay? And how it's all Roman law, and they want to assault you with one of their so-called contracts. A penal action is an action on a penal statute, an action for recovery of penalty given by statute. Where an action is founded entirely upon a statute, the only object of it is to recover a penalty or forfeiture. Such action is a penal action. The words penal and penalty in their strict primary sense denote a punishment, whether corporal or pecuniary, imposed and enforced by the state for a crime or offense, okay? So offenses have to do with penal and penalties. And so it's always an offense brings a penal or a penalty. The noun penalty is defined forfeiture to be forfeited for non-compliance with an agreement, okay? They assault you with one of their little contracts. The words forfeit and penalty are substantially synonymous. A penal action is one founded entirely on statute, brought with the sole object of recovering a penalty or forfeiture imposed as punishment for a specific offense, while a remedial action is one brought to obtain compensation or indemnity. And so, a penal action is one founded entirely on statute. The only object is to recover a penalty or forfeiture imposed as a punishment for a certain specific offense, okay? So penal and offense kind of work together, or penalty and offense, while a remedial action is one brought to obtain compensation or indemnity. A penal action is a civil suit brought for the recovery of a statutory forfeiture when inflicted as punishment for an offense against the public. Such actions are civil actions, on the one hand closely related to criminal prosecutions, on the other to actions for private injuries in which a party aggrieved may by statute recover punitive damages. Okay, so that's why the whore sitting up on there in the Kangaroo court when you ask them, you want to know the nature of the action that's this cause that they're doing against you, and he'll tell you it is quasi-criminal. Okay, well, he doesn't want to come out and tell you this is a civil action. Okay, because then you'd come out and say, well, where's the contract? Okay, see, they're liars. Okay, they're Satanists. Don't get me going. Okay, this is all coming from the Roman cult. And the bottom line is, if you go into commerce, okay, then you convert yourself into a slave. This is and Clearfield Trust Company versus United States. Governments descend to the level of mere private corporation and take on the characteristics of mere private citizen, where private corporate commercial paper and securities is concerned. For purpose of this suit, such corporations and individuals is regarded as entities entirely separate from government. And so either you're the king or you're a slave. Okay, there's nothing in between. If you go into commerce, you're a slave. That's why if you watch the end of my video, I always say that I can accept the commercial paper as an extremely less desirable alternative. But I ask for gold or silver coin. And that's why there's no contract. I'm only taking the commercial paper because that's what everybody does nowadays, all the brain-dead idiots out there. And now a little advertisement. CubeYard.com. For great custom websites, domain names, and hostings, go to CubeYard.com. Use coupon code CY172 for 20% off your first order. CubeYard.com, your source for websites, domain names, and hosting. And so then back to the topic at hand, we're going to talk some more about liars, okay? An attorney for the plaintiff cannot admit evidence into the court. He's either an attorney or a witness. Manifestly, such statements cannot be properly considered by us in the disposition of a case, okay? So that's talking about testifying by the liars, okay? They do it all the time. And if you don't object to it, then the bail priest is going to allow it and consider it the truth. Under no possible view, however, of the findings we're considering can they be held to constitute a compliance with the statute, since they merely embody conflicting statements of counsel concerning the facts as they suppose them to be, and their appreciation of the law which they deem applicable. There being, therefore, no attempt whatever to state the ultimate facts, by a consideration of which we would be able to conclude whether or not the judgment was warranted. And so, again, they're talking about testifying by the liars. Okay, no instruction was asked, but as we have said, the judge told the jury they were to regard only the evidence admitted by him, not statements of counsel. The prosecutor is not a witness and should not be permitted to add to the record, either by subtle or gross improprieties. Those who have experienced the full thrust of the power of government when leveled against them know that the only protection of the citizen he has is in the requirement of a fair trial, okay? And when they're sitting there testifying, it's not fair. Statements of counsel in brief or in argument are not sufficient for motion to dismiss or for summary judgment. Statements of counsel in brief or in arguments are not facts before the court and are therefore insufficient for a motion to dismiss or for summary judgment. Allegations of, and this is, I got some stuff in square brackets here, and we're not going to read that, okay? That just kind of expands it for thought based on what in the case of a traffic ticket or something like that, okay? So, but we're not going to read it because that's really not part of the site, okay? It's in square brackets, which means it's not there as far as the site's concerned. Allegations of legal conclusions cannot be permitted to supply essential allegations of fact. A mere conclusion of a pleader cannot be availed of to initiate and invite an issue of fact. Allegations of conclusions of law tender no issue, okay? So that's these Satanist pigs that they send out to assault you and give you out these tickets. It means nothing. Where there are no depositions or affidavits, the court has no facts to rely on for summary determination. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. A pleading cannot be aided by reason of facts not averred. Facts necessary to a cause of action but not alleged must be taken as having no existence. So these Satanists, that's what these Satanists like to do, okay? The government of the Virgin Islands versus Giroux cannot assume facts not in evidence, even if the judge believes the facts to be accurate, okay? So if the liar is sitting there testifying and then you don't object to it or bring this up, then the whore on the bench will sit there and play stupid and say, well, it must be the truth, unless you bring up the fact that they cannot assume facts not in evidence, even if they believe the facts to be accurate. The clerk masquerading as a judge is sitting there playing stupid. If the liar testifies and you do not object, the clerk masquerading as a judge will accept it as true. The Roman cult's bar members will represent you whether you like it or not. If you do not object, the clerk masquerading as a judge will accept it as true. See the do-it-yourself Kangaroo Courts number 5 video testifying by the liars. See the do-it-yourself Kangaroo Courts 1 and 2 that describe how when a judge is dealing with a statute, he's a bought and paid for clerk masquerading as a judge. And now another little advertisement. Check out my other videos. Bankster Thieves 1, 2, and 3, Churchianity series, Bankrupt Corporate So-Called Governments, Bar Members 1, 2, and 3, Do-It-Yourself, How Not to Volunteer for the Selective Service of the Draft, Martial Law is Here, Do-It-Yourself, No Income Tax, Do-It-Yourself, No Sales Tax, Do-It-Yourself, Traffic Stops 1 and 2, Do-It-Yourself, Free Mail 1 and 2, Do-It-Yourself, Kangaroo Courts 1, 2, 3, 4, 5, 6, and 7 now. It's getting up there. Anyways, back to the topic at hand. This is the Uniform Commercial Code, Section 1-206, Presumptions. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. So if you don't defeat their presumptions, you're dead, okay? They got you. They got you. And so you have to know what presumptions they're taking, and you have to defeat them. And their biggest presumption they're taking is that you're one of the slaves. Every taxpayer is assessed to a trust having sufficient interest in preventing the abuse of the trust is to be recognized in this court's prerogative jurisdiction. A citizen of the United States is a civilly dead entity operating as co-trustee and co-beneficiary of the public charitable trust. The constructive cesticate trust of U.S. Inc. under the 14th Amendment, which upholds the debt of USA and U.S. Inc. And that's a summary taken from the Congressional Record, June 13, 1967. It's a summary of 5 pages. And this is all coming from the Roman cult. This is taken from Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of mort main. And yet still it was found difficult to set bounds to ecclesiastical ingenuity, for when they were driven out of all their former holds, they devised a new method of conveyance by which lands were granted, not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use, and receiving the actual profits while a season of the land remained in the nominal fief, who was held by the courts of equity, then under the direction of clergy, still under the direction of the clergy, the Roman cult, to be bound in conscience to account to assist to use for the rents and emoluments of the estate. That's talking about taxes. So this is all coming from the Roman cult, and it is to these inventions that our practitioners are indebted to for the introduction of uses and trusts, the foundation of modern conveyancing. So this says volumes, okay? First of all, the cesticate trust comes from a Roman cult. Secondly, the taxes are the rents and emoluments of the estate. And thirdly, it's been going on from at least 1835. And so as far as the copyright is concerned, okay, now that we've done the foundational stuff, I have ran copyright notice in newspaper, and that is all commercial, and it's quite expensive too. And I wouldn't do it again, quite frankly. I've recorded numerous copyright notices with the county recorder. That's common law, okay? That's a common law copyright notice, and you're basically saying to everybody, if you use this name, these are the fees. It's no different than a movie star or a songwriter or any other thing. In my notice and demand, which is my Estoppel certificates, I always tell them that the name is copyrighted. And in fact, I wouldn't even bother recording it anymore, although recording something is useful, but you know, it's not that big of a deal. It's when I send out my notice and demand with my Estoppel certificates, I tell them then and there, and that's really all you need to do. You can hold them personally responsible and their subordinates. And so if you send that out to everybody that you might have to deal with, well, then you got your bases covered. got to remember, though, that you're dealing with thieves and pirates, okay? These people, it's Roman cult, okay? They're thieves, they're pirates, they're criminals. Why would you expect a thief and a pirate to be anything but a thief and a pirate? And if you have to get a remedy on that copyright, you're going to have to go to the thieves to get a remedy. And, you know, so are you going to get a remedy? You might. I haven't ever heard of anybody getting a remedy, quite frankly. These people are cowards, okay? The pigs and their bosses are operating a criminal street gang. They're engaging in fraud to get you into one of their so-called contracts. And think about it. Why do they lie? Because they're cowards. They don't want to come out and tell you, oh yeah, we're perjuring our oath here, and we're going to get you into one of our satanic contracts. They're not going to tell you that. They're cowards. They're liars. They're afraid to tell the truth. They engage in fraud on a wholesale basis. Matter of fact, that's why they use the Sesticate Trust. They don't want to tell you that this is really not you. This is the Sesticate Trust. These people are cowards. They're liars. They're afraid to tell you that they're perjuring your oath and assaulting you with their so-called contracts. All liars are cowards. And I've done commercial liens and did not get anything from it, okay? I've done several. I don't know of anyone who has ever collected anything from a commercial lien. I built cases against people and got them removed, okay? That's where the remedy lies, in my opinion. In my opinion, building a case against criminals and filing criminal complaints is far more effective. If you do anything pursuant to their statutes, you're making yourself a slave. I would never do anything, some copyright statute. Screw their copyright statute. They can put it up their rectal orifice. I don't do things pursuant to their copyright statute. Common law is the only remedy. In some of my Estoppel certificates that I sent out, sometimes, usually they don't say anything. If they're smart, they don't say anything. Sometimes they send me back positive responses, but sometimes, usually they don't say anything. So anyways, the negative response, I sent a Pennsylvania Attorney General a notice and demand, one of my Estoppel certificate notices, and they sent back a letter making all sorts of legal determinations and presumptions and said they'd force their fictitious color of law on me. On March 10th, 2010, I filed a criminal complaint, sent it to the Chief Judge of the Pennsylvania Supreme Court and the U.S. Attorney, and the U.S. Attorney sent me a letter back stating that they were referring the matter to the FBI. And on the 22nd of February 2011, I checked the Pennsylvania Attorney General's website, and it says William H. Ryan Jr. becomes acting Pennsylvania Attorney General. And so what happened, there's the website, and there it gets in closer. The only time they have someone that's acting is when they removed the other guy before his term was up. So I think I got his butt removed. Now, I got to tell you that I have no proof that that's what happened, that I got his butt removed, but it's amazing how many times I do this kind of stuff. And the next thing you know, there's somebody else in there. This is the Ohio Director of Public Safety, Henry Guzman, sent me a letter doing the same thing. In August 2009, I filed a criminal complaint, sent it to the Ohio Attorney General and the Chief Judge of the Ohio Supreme Court and the State Bar, the U.S. Attorney, etc. On the 22nd of February 2011, I checked the Ohio Public Safety website, and it says that in January 2011, Thomas P. Charles was appointed Ohio Director of Public Safety, and he was the former Inspector General for the last 13 years. And there's their website. And so after filing criminal complaints, I've seen numerous people resign or removed, 3 U.S. attorneys in Arizona, 3 U.S. attorneys in Texas, the U.S. Attorney General Alberto Gonzalez, U.S. Solicitor General Paul Clements, other Solicitor Generals. There's more than just what's listed here, quite frankly. This is just a few. And the Pennsylvania Attorney General, Ohio Public Safety Commissioner, IRS Commissioner, Alberta Attorney Generals, Congressmen, Senators. Anyways, but if the watchmen see the sword come and blow not the trumpet, and the people be not warned, that the sword come and take any person among them, he is taken in his iniquity, but his blood will I require at the watchman's hands. This is my effort to make sure I'm blameless on Judgment Day, and I hope you're blameless on Judgment Day too. Either you're part of the problem, you're part of the solution. You're now watchmen. Circulate this video far and wide. Copies of these documents can be found in my private group at Yahoo called Administering Your Public Servants. I have YouTube videos that are videos of private information shares that show these and other court citations are available for a donation. And this last paragraph is for all the Satanist order follower revenue officers operating in their private capacity under the Federal Tax Lien Act of 1966. Donations to support this work are appreciated, but these revenue officers can put their IOUs up their rectal orifice, their commercial paper. I prefer a gold or silver coin, but as an extremely less desirable alternative, I can accept the IOUs, the Federal Reserve notes, the commercial paper, the PayPal gifts, checks, money orders, etc. Send me an email for particulars. Anyways, my blog is sovereigntyinternational.wordpress.com. My website is sovereigntyinternational.fyi. My email address is engineerwin@yahoo. My YouTube profiles, I got two of them, Sovereign Living and Sovereignty International. My Facebook community page, I deleted it due to censorship on the part of Facebook. My private group, Sovereignty International, is being deleted. It takes time to ban 17,000 people off my Facebook group, and I'm not going to let Facebook profit from my hard work. My Yahoo private group called Administering Your Public Servants. My Google private group is called Administering Your Public Servants. I appreciate you taking the time to watch my video, and I hope you have a real nice day.